Good morning, bonjour, tansi. Welcome to the Standing Senate Committee on Aboriginal Peoples. Today we are continuing our study on Bill S3, amending the Indian Act, elimination of sex-based discrimination. We will start by introductions. First of all, my name is Lillian Dick. I'm from Saskatchewan, and I have the honor and privilege of chairing this committee. And I will now have my colleagues introduce themselves, starting on my right.
Norman Doyle, Newfoundland.
Murray Sinclair, Manitoba.
Thank you, Senators. This morning we have two panels. Our first panel is composed of Lynn Gehl and Nicholas Gehl as individuals. We also have Mary Eberts, the co-author of the Matrimonial Property on Reserve, a very well-known lawyer. And we also have from Aboriginal Legal Services of Toronto, Emily LaHaye, the staff lawyer. And witnesses, you have hopefully about 10 minutes each to present. We will start with Lynn Gehl, to be followed by Emily LaHaye, and then to conclude we will have Mary Eberts. So Lynn Gehl, you have the floor.
Kwe makinakdodam, Kwakanagon and Dinjaba, Peterborough Megwandira, Gizigate, Manado Kwe, Indigenous Cause and Da, Shaganashi, knows when Lynn Gehl, and Donis and Don, Shigos and Don, Shimis and Da, and Wijigi Canon Da, and Wijigi Wagon and Da, up to go and Do, Chanan Dam, and Ishnabi Kwe, Wayon. Thank you for inviting me today. I'm really happy to be here. I'm happy to be here in Algonquin and Anishinaabe territory, more home territory. So I guess it's been a 32-year journey for me to be here. And the first thing I guess I should do is explain the issue of unknown and unstated paternity in the Indian Act. Prior to 1985, the Indian Act explicitly codified a provision to protect children of unknown and unstated paternity. And through the 1985 amendments, the Indian Act became suspiciously silent on the issue of unknown and unstated paternity. And that's also when INAC developed their proof of paternity policy that makes an assumption that an unknown and unstated paternity is a non-Indian man. So when I applied for Indian status in 1994, I didn't know what they were going to do because of my paternal grandfather. I didn't know who he was. And what I found out is they made the assumption that he was a non-Indian person. And as a result, I was hit by it was determined that I was a non-status Indian. And so that's the issue in a nutshell. You might have to hear that a few times to get that, which is fine. So the remedy, the first thing I want to talk about is the remedy that was offered in Gehl. I don't agree that I should be a 6-2. I think I should be a 6-1A. The comparator group would be the great-grandmothers and the grandmothers who were never enfranchised. Them and their descendants are 6-1As, and I think I should be a 6-1A because I was born before 1985. So that's the first thing I want to say is the judges gave me a remedy that introducing a new sex inequality. So another thing I want to talk about is INAC and the Department of Justice shift from law to policy. So it's become clear to me that INAC and the Department of Justice are of the position that for the most part they will only address known sex discrimination that the court has identified as charter violations. This means that matters such as unknown and unstated paternity and matrilineal lineage, the 1951 cutoff, which have not been recognized as charter violations, may not be addressed in law the way they should be. INAC argues that these should be addressed at the policy level, and I'm concerned because through Gehl we learned a lot of things about what INAC does at the level of policy. So, for example, it took INAC 32 years to develop their proof of paternity policy, and they also, in those 32 years, they flung their arms in the air and they said they weren't capable of making a policy, they weren't capable of good judgment. Another thing that we learned through Gehl, we learned that INAC does not disclose to the public their practices, standing operating procedures, aids, directives, and policies, both oral and written. And INAC developed a new we learned that INAC developed a new post-MacGyver policy that instructed staff that they could no longer assume non-Indian paternity. but they didn't disclose that policy to the public. And within that policy, they also said they weren't going to reopen old files. And another thing that we learned through Gehl was that INEC refuses to disclose evidence of policy so they can be properly adjudicated through court. And so in summary, I'm concerned that when the court fails to determine charter violations and addresses matters at the policy level, that opens the door for INEC and the Department of Justice to shift and create more sex discrimination. So it's also not lost on me that INEC and the Department of Justice crafted the silence in law on the issue of unknown and unstated paternity so they could continue with their interpretive framework of the need to get rid of all the Indians at all costs, rather than the interpretive framework of good moral judgment as the charter guides. And that's how they continue with their sex discrimination at the policy level. So we must not allow INAC to unilaterally develop policies without solid guiding parameters that will protect vulnerable Indigenous women and girls from INAC's known interpretive skew and poor behavior. We need to move beyond adding carefully considered clauses and terms to the bill. We certainly cannot allow INAC to construct the clauses needed. We need to place parameters around the clauses and terms as a measure to make sure Indigenous women and girls do not face unreasonable barriers. Otherwise, INAC and the Department of Justice may very well develop unreasonable criteria of evidence, such as the requirement of police reports, the requirement of rape kits, the requirement of social workers and therapists reports, the requirement of photographs of bruising and tears in the vagina. INAC are government bureaucrats who seek to eliminate Indians at all costs. They are not concerned with understanding that many Indigenous women and girls will not report rape to the police. For valid reasons, Indigenous women and girls don't trust the police. Many do not want to disclose situations of incest, and many do not want many don't have access to social workers and therapists. Indigenous women and girls must not be put through the eye of INAC's needle that further harms and violates them. INAC employees are not trained social workers or therapists qualified to address and administrate situations where sexual violence and abusive partners are involved. I personally think that all situations where an unknown or unstated paternity is involved, that these files should be directed to an independent decision-making body. Otherwise, INAC, with its skewed interpretive framework, will continue to discriminate and impose additional harm at the policy level. So, Senators, I ask you to collectively and carefully consider how we can best protect Indigenous women and girls from economically driven and unqualified INAC bureaucrats that have proven they lack good moral judgment. Needed is a solution that serves the most vulnerable in our society. Needed is a solution that prevents INAC from creating additional indignities to Indigenous women and girls who are the victims of sexual violence. So there are some disturbing statistics that we should consider, and through reason, it becomes clear that Indigenous women and girls with disabilities or without disabilities are bigger targets of sexual violence. That they are more vulnerable and more likely to have a child of unknown or unstated paternity. So, for example, 83% of women with disabilities or developmental disabilities, they've been victims of sexual assault. 84% of homeless Indigenous girls have been sexually abused. So there's some real statistics there that we need to pay attention to. So all our laws and policies and practices must care for them. This is what good governance structures do, care for the most vulnerable rather than force them to continually deal with barriers of exclusion and harm. So in conclusion, I'm asking for a 6(1)A remedy. And I ask senators to seriously consider placing guiding parameters around INAC's policymaking process as a way to protect Indigenous women and girls. And then my overall position regarding the current version of Bill S3 is that it does not address all the sex discrimination in the Indian Act and that it should not move forward. Senators have a role in ensuring that all the sex discrimination is addressed. INAC must move beyond what has been determined to be charter violations. The position that Section 1 of the Charter needs to be tested must not be a barrier here. Not addressing the 1951 cutoff because the court said that the issue was a matrilineal lineage versus sex discrimination was wrong. We know judges are only human, and that's prone to mistakes. And we know We know judges need more training in understanding Indigenous women's issues. So said another way, I'm of the position that the hierarchy created in 1985 between Indian men and their descendants, and as they were registered as a 6-1A, and Indian women who are only registered as a 6-1A, that must be abolished if you want to eliminate the sex discrimination and end this process of amending the Indian Act. Miigwech.